nature with a procedural step which otherwise could either be cured or waived in ordinary civil proceedings could result in a fatal consequence to election petition. A lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal, for the hearing of the election petition for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the court. It is tried law that under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that the election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements of oath of witnesses. 3, copies or lists of every document relied on at the hearing of the petition. A petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall used in this legislation makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or it is difficult to prove the same petition. In the instant case, the petitioner's pleadings were deficient. While they complained of non-compliance with the Electoral Act against first respondent, their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these 3 consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment.
I will call on my land brother, my immediate left, to deliver his own judgment.
I have read the lead rulings and judgments of my learned brother, H.S. Samani JCA, in the above consolidated petitions. I agree with his reasoning and conclusion in each petition and adopt same as mine. I add a few words for emphasis. Petition number 3. Ground 1 of the petition is that the respondent was, at the time of the election, not qualified to contest the election. The first complaint under this ground is that the purported sponsorship of the second and third respondents by the fourth respondent was rendered invalid by reason of the third respondent knowingly allowing himself to be nominated as the vice presidential candidate, whilst he was still a senatorial candidate for the Borno Central constituency. The controversy about the third respondent knowingly allowing himself to be nominated in more than one constituency was the subject matter in PDP against INEC and others, reported in 2023 LPELR 60457 SC. The Supreme Court Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, in their concurring opinions, held that the third respondent, having withdrawn his nomination and personally delivered the notice of withdrawal to his party, fourth respondent in this petition, on 6 July 2022, he was no longer a candidate for Borno Central constituency senatorial election in his subsequent nomination as the vice president for the presidential election was not multiple nomination. The opinion of the Supreme Court of the Supreme Court, Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, is not a comment or observation made in passing. It is an exposition of the law on withdrawal of a candidate from an election and the allegation that the third respondent knowingly allowed himself to be nominated as the vice presidential candidate while he was still a senatorial candidate for Borno Central constituency. Concurring opinion forms part of the lead judgment, and it is meant to complement him by way of addition or an improvement on the issues resolved in the lead judgment. See Unwana against FCDA, Oloruntoba Oju against Abdurrahim, and both and others against Just Electricity Distribution Company PLC. Citations supplied. The Supreme Court, having rendered its considered and definite opinion on the validity of the nomination of the second respondent as vice presidential candidates of the fourth respondent, attempts to reopen the issue in this court is a misadventure. The second complaint is that the second respondent was at the time of the election not qualified to contest for the office of the president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483 on 4th October 1993. The contention of the learned counsel for the petitioners is that the order of forfeiture made by the court is a fine under Section 137(1)D of the 1999 Constitution of the Federal Republic of Nigeria. It is a settled principle of interpretation that when the words used in the provisions of the Constitution are clear and unambiguous, same must be given their plain and ordinary meaning, unless to do so will lead to absurdity. See Abegundi and other cases cited here. The context in which the word sentence is used in Section 137(1)D of the Constitution connotes formal pronouncement awarding punishment after conviction for an offense. Conviction is a finding of guilt after an indictment, arraignment, and trial. See Kole Osho against FRN, Mohammed against Olawumi, Modu against Federal Republic of Nigeria. Therefore, the words sentence, imprisonment, and fine used in Section 137(1)D of the Constitution definitely connotes only a punishment imposed on a defendant following an indictment, trial, and conviction for an offense. See Babangida Usman against the state. Citation supplied at 40 to 41. Sharif against Federal Republic of Nigeria. Citation supplied. In civil forfeiture or a non-conviction-based forfeiture proceedings, in civil forfeiture or non-conviction-based forfeiture proceedings, the government only needs to show by preponderance of evidence that the property is a proceed of crime or was used to facilitate a crime. Criminal forfeiture, on the other hand, is seizure of a property connected with a crime after obtaining conviction and as part of sentence or punishment for the crime. Civil forfeiture is not a conviction or verdict of guilt after an indictment, trial, and conviction. See Jonathan against Federal Republic of Nigeria, citation supplied, where the Supreme Court Parkas JSC considered the provisions of Section 17 of the Advanced Fee Fraud and Other Related Offences Act and persuaded by the decisions of the various courts across the world, held that civil forfeiture is an action in rem embarked upon when the interest of the government is merely to recover the proceeds of unlawful activity. The court also held that an application for interim forfeiture of property that is not predicated on conviction of the owner of the property will necessarily be an action in rem, because it is the recovery of the property that the law aims at. A forfeiture order by a foreign court can only be accepted and recognized by a court in Nigeria for the purpose of Section 137(1)(d) of the Constitution, if it is made after an indictment, trial, and conviction, and properly proved as required by Section 49 of the Evidence Act. In addition, the conviction and sentence must be shown to have been a product of due process of law. Compliance with the process of law has to be determined by the procedure and standard set by Section 36, subsection 5 and 6 of our Constitution. The forfeiture order being relied on by the petitioners has not been shown to be a result of a process similar to the one set by our Constitution for a trial of a defendant for an offense. The appellant counsel relied on Austin against United States, citations supplied, and Teams against Indiana, decided on 20th February 2019. The forfeiture proceedings in two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment, such as fine, for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money, after forfeiting the properties listed under forfeiture of assets, etc., certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, etc., certain persons decree number 53 of 1999 as punishment.
Meet my cards. Huh? It shock you, Abi. I say your customers, they confused when you as a business owner send them a bank account with a name different from your business name. You know pure now. Sign up for a MoneyPoint business account and get an account in your business name in minutes.
Whatever it takes to make sure you have a business account opened in your business name, we'll do it as your sure banker. Open a bank account in your business name with MoneyPoint.
Don't let your customers see you like scammer. Kitty cat, huh? Come here, we'll play now.
You don't want me?
On non-compliance with the provisions of the Electoral Act, the allegations are basically predicated upon electronic transmission of the election. A global reading of the Electoral Act 2002, particularly sections 47(2), 61(5), 62(1), 65(1) to 8, will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC regulations and guidelines for the conduct of elections 2022, the first respondent made provision for electronic transmission and physical stroke manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provide that at every level of collation, where any copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officials shall use duplicate hard copies issued to the Nigerian Police Force and agents of political party to collate results. It is therefore not correct that it shall not be possible to collate results of the election where results have not been electronically transmitted. By law, the INEC Regulations and Guidelines for the Conduct of Elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act prevails. See Odeneye against Efunuga, Nyesom against Pisasai, citation supplied. Section 134(2) of the Act. By Section 134(2) of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECAT at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers, so as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the result was still being uploaded on the IREF? So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW12, the petitioners exercised that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral Act provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agent raises a presumption that if those forms had been produced, would have been unfavorable to the petitioners. The first respondents in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IREF was due to a technical glitch which occurred on their transmission system, which was rectified within a few hours. All that the petitioners could do was to bring a PW1, a member of the second petitioner, who claimed to be a software engineer and an employee of Amazon. She had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the markets, or to be persuaded or intimidated by threats on social media? That is not the way of the court. See the admonition of Toby JSC in Buhari against Yaradua on a similar situation like the instant case, citation supplied. Thus, the petitioners not only failed to prove non-compliance with the Electoral Act, they failed to prove that the non-compliance substantially affected the result of the election declared by the first respondent. It is settled that even if non-compliance with the Electoral Act is established, if there is evidence that despite the non-compliance, the result of the election was not affected substantially, the petition must, as a matter of law, be dismissed. See Abubakar and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. Cielelu, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that would do violence to the provisions of the Constitution and fail to achieve the goal set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of this Constitution, 14(1) and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs our constitutional principles of freedom, equality, and justice. Democracy and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. The principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution being urged on us by the petitioners is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality and justice, democracy and social justice, and participation of the people in their government enshrined in our Constitution. It strikes at the very foundation of our Constitution. It is capable of further dividing the citizens of this country. The politicians are good at using all sorts of means and sentiments to divide the citizens of this country. The interpretation being urged on us is their latest invention. In that regard, learned brother, I agree and conclusion, I adopt same as mine.
I hereby abide by the orders laid therein. As for 05, I adopt my reasoning in respect of the third ground, and I also dismiss the petition. On the whole, I too dismiss each of the three consolidated petitions. I abide by the order made in respect of the petition in the lead judgment.
My learned brother, by my extreme right, shall present his own judgment.
Long last.
There's still one more? Yeah? It's not complete, we do know.
No, just
Okay.
I had earlier read in draft the rulings and judgments of my learned brother, Aruna Simon Samani, in these consolidated petition numbers CAPEPC 03, 04, and 05, 2023. I am in complete agreement with His Lordship's reasoning and conclusions on all of them. First, for petition numbers PEPC 04, 2023, that is the Allied People's Movement petition, I am of the very fixed view that the issues agitated by the petitioner therein concerning third respondents' alleged disqualification by reason of matters connected to or surrounding his running mate's nomination and relinquishing of his earlier nomination by his party for the Boronu Central Senatorial District having been settled on their merit by the Supreme Court in its judgment, in appeal numbers SCCV 501, 2023, in third and first respondents' favor therein, with the Apex Court even holding that the said issues did not disqualify them, that decision constitutes issue estoppel, being status defining, and so judgment in rem it binds every person, including non-parties to the suit, like the petitioner in petition number CAPC 04, 2023, C. Kotun, and Oyekomi, Soson, and Odemuyiwa. Furthermore, by the doctrine of stare decisis, it also binds this court. In fact, it will, in my humble opinion, amount to judicial heresy for this court to involve itself in inquiring by whatever guise into that same issue already settled by the Apex Court. Coming to petition number CA03, 2020, of Peter Obi and another versus INEC and others, and CAPC 05, 2023, Atiku Abubakar and another, again, I am of the very fixed view that the two sets of petitioners did not by any means discharge the burden on them of proving that the results of the presidential election of 25th February 2023 as declared by first respondent were incorrect. Incidentally, their burden is even made heavier by the legal presumption that the votes of an election declared by the official organizing body that INEC are correct, and it is for the person asserting the contrary to prove it, Buhari and INEC, see Buhari and INEC. Even their resort to first respondent's failure to keep its initial promise to upload polling unit results of that election to its result being portal IREV real time, which failure the alleged evidence is election manipulation, does not help them. And specifically on this allegation of manipulation of election results, the point must be made that since it is their case that from the word go that the election results in issue were manipulated by first respondent in favor of second respondent, and specifically that the manipulation took the form of, quote, programmed failure of the technological device, machines, that is beavers, by first respondent by intercepting the results, quarantining, warehousing, and filtering such results before releasing them to the IREF portal. 2, INEC replacing its in-house IT expert at the 11th hour with a rogue staff, all in a bid to completely control, monitor, and filter data transmitted from the beavers devices to the electronic system. And 3, that Globacom, the internet provider for the beavers and electronic system, was also disconnected by first respondent to enable it to manipulate the results, with the petitioners in CA, that is the article petition, even going further to undertake to call evidence to prove all those allegations. The burden of proof was on the petitioners to prove those assertions, and that is regardless of whether they are positive or negative. After all, it is they who would have failed in the case if no evidence at all was adduced in their petitions. See on that sections 131 of the Evidence Act, Buhari and INEC, Aladegbemi versus Fasomade, Elias and Disu Dashi and another Abrat and Railway, Northeast Railway Company. I have taken all this time in making this point because of the argument of both sets of defendants that they only made negative assertions in their petitions, when they alleged that there was nothing wrong with first respondents' transmission system and IREF, so they had no burden to prove it. That the burden of proof was on the respondents who they said positively asserted glitch in real-time transmission of their results. Petitioners who directly made manipulation of its e-transmission system by first respondent to favor of second respondents, a pillar of their case, cannot be heard to say it is respondents and not them that had the burden of proof in this case. Incidentally, that assertion of petitioners that INEC simply closed down or blocked its IREF and e-transmission system from the public to enable it to manipulate the election results in favor of second respondent also takes me directly to the more important question in the petition, namely whether that allegation is even worthy of belief, given the results declared by INEC for them and the second respondent in the election. To answer that million-dollar question, I deem it necessary to resort to the probabilities arising from the facts of the case. That test, otherwise called the probability test, which test celebrated Judge Chukwudifu Akonne Oputa, JSC, always maintained, and I quote him, is the surest road to the shrine of truth and justice. In the cases of, he said so in the case of Dibiamaka and others, and in Ojegele and others, the first 1989 and the second 1988. I gave the citations. Here, the assertion of petitioners is that first respondent INEC merely used the excuse of glitch in its IREF portal to block the public from seeing its polling unit results real time so that it could manipulate, and indeed actually manipulate, the 25th February 23 presidential elections in favor of second respondent. It is their further contention that the manipulation of IREF by INEC with the said phantom glitch in favor of second respondent was nationwide. The question is, do the results declared by INEC support that hypothesis? They say the taste of the pudding is in the eating. I shall therefore now try to walk us through some of these election results to see if that assertion of petitioners is supported by the results declared by INEC and so probable and worthy of belief. In doing that, I shall randomly pick on the results of some states of the Federation and the Federal Capital Territory. I shall be relying on the state summary of the results, that is from ECD, declared by INEC and has also attached their petition by the petitioners in CAPC 05, that is Article's case, which result was also tendered by both sets of petitioners and respondents. So I take first Abia State. There, second respondent, the alleged favored candidate of INEC, for which it was said to have shut down its IREF to manipulate results, only garnered a miserly 8,914 votes. That is as against the Labour Party, which by INEC's declaration polled as many as 327,095 votes. Even the other set of petitioners, complainants, the PDP and its candidates, scored more votes in Abia than INEC's purported favored candidate. He also scored 22,676 votes in Abia and was so recorded by INEC. Those votes alone are close to 3 times the votes of second respondents, for whom INEC was said to have manipulated results by closing down its IREF, so that the public would not witness his manipulative activities in favor of second respondent. In Enugu State, the same favored quote-unquote candidate, second respondent, was again declared credited by INEC to have polled only 4,772 votes in the entire state. Meanwhile, the Labour Party and its candidate were again declared by manipulative and quote-unquote and unfriendly INEC to have scored as much as 428,690 votes in that state. In the same Enugu, PDP and its candidates was also declared by INEC to have polled 15,745 votes, a number that is also nearly 3 times the votes of the so-called favored second respondent. In Anambra State, the same purported favored candidate, second respondent, was declared by his alleged friend INEC to have scored only 5,111 votes. Meanwhile, the Labour Party, whose candidate, first petitioner in CAPC, I must take judicial notice of, via Section 124 of the Evidence Act, is from that state, again was declared to have polled as much as 584,621 votes. Again, like Enugu State, the PDP and its candidate was declared by INEC to have polled 9,036 votes, a number that is also nearly double the votes of, quote, INEC favored, end quote, second respondent. In neighboring Delta State, the same INEC favored candidate, second respondent, was declared by INEC to have scored 90,180 votes. That is as against the Labour Party and its candidate, which is credited by the same biased, quote and unquote, INEC, to have scored as much as 179,917 votes. In that same Delta State, the PDP and its candidate scored 161,600 votes, again nearly double the votes of second respondent. In Adamawa State of the PDP and its candidate, the same favored second respondent was declared by INEC to have scored only 105,648 votes, while the PDP and its candidate were declared by the biased, quote and unquote, INEC to have scored as much as 214,012 votes. In Imo State, the same purported INEC favored candidate, second respondent, was declared by INEC to have scored only 66,406 votes, while the Labour Party and its candidate is declared by the same INEC to have polled as much as 360,495 votes. In Ebonyi State, the Labour Party again scored as much as 259,738 votes. That is as against alleged INEC-favored second respondent, who by INEC's declaration, that is his friend's declaration, again polled a relatively miserly 42,402 votes. The PDP is said to have scored 13,503 votes there. Even in Lagos State, where second respondent was once held sway as elected governor, the Labour Party and its candidate was again declared by bias, quote and unquote, INEC to have beaten second respondent with almost 10,000 votes. Labour Party was declared by INEC to have polled 582,455 votes as against 572,606 polled by second respondent and so declared by INEC. It is a similar story in the federal capital territory of Abuja, where INEC has its headquarters and supposedly carried out, stroke directed, all its, quote, manipulative and biased activities in favor of second respondent that petitioners claim he did in the election. Second respondent and his political party still lost there. In fact, by the result, second respondent friendly, quote and unquote, INEC declared in the federal capital territory of Abuja, second respondent could not even make 25% of the votes, total votes cast there. He was said to have polled only 90,902 votes. That amounts to just 18.991% of total votes cast in the FCT, yet INEC declared that result. That is as against 281,717 votes, amounting to 58.856% of the total votes, the same INEC declared for Labour and its candidate. There are also other states, including Katsina State of the immediate past president of this country, a member of the second respondent, who was still in office at the time of the elections, in fact, as I take judicial notice of video section 124 of the Evidence Act. There again, second respondent and his party, the APC, also the then sitting president, was declared by the same INEC to have lost to the petitioners in CAPC 05-2023, that is Atiku Abubakar. Now, if all these results declared by INEC for each of the states for the 2 sets of petitioners, and second respondent is anything to go by, then INEC must be an abysmally poor manipulator. if not even an imbecilic one. Surely it would not go through all the stress of closing down its IREF and blocking the public from seeing its manipulative efforts in favor of second respondent, as alleged by the petitioners, only for it to still end up favoring the petitioners with jumbo votes and posting miserly figures for its favored second respondent. It is said that all men stamp as probable that which they would have said or done under similar circumstances, and as improbable that which they themselves would not have said or done under the same set of similar circumstances. Things inconsistent with human knowledge and experience are properly rated as improbable. End quote. See again Oputa JSC on this, in Onwa and the state and Bozin and the state. At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agree that they had agents in the polling units? I have thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building block of election results. That much is stated in paragraph 90 of INEC guidelines and for the election, and also Wobuda Nono and Awuse and Odele. In short, the allegation of the petitioners that INEC shut down its IREF to manipulate votes for second respondent just does not add up for me. If anything, the probabilities arising from the results INEC declared nationwide as S-rate above rather seem to me to eloquently support its position that its inability to upload the polling unit results real time, as earlier promised, was not deliberate but caused by technical issues outside its control that afflicted its e-transmission system, which issues it claims made it impossible for its e-transmission system to map the uploaded polling unit results for the presidential election to any specific state. That it claims is unlike the much smaller National Assembly elections that were conducted simultaneously with the presidential election. It is that phenomena it describes as glitch that was giving it an HTTP 500 error, which eventually resultantly delayed real-time public viewing of the said polling unit results. That conclusion also takes me to another big issue in this case, namely the evidential value of the European Union Observer Mission report on the 2023 presidential election, over which quite a mountain has been made up by both sets of petitioners. That report was tendered by the petitioners in petition number PEPC, that is Obia and another, as Exhibit X2, and by the petitioners in CEPEC 05 as Exhibit RA27. The impression given by both sets of petitioners is that the said report, which in any case has been even ruled admissible by us in petition number CAPEPC 03-2023, is like gospel truth of what happened in the election. And so it must be accepted by this court, and the conduct of the presidential election declared corrupt or at the very least below par, regardless of whether or not its authors presented themselves in court to defend their opinions. That stance, I am afraid, is a non sequitur. It's a complete non sequitur. Without the makers of that report presenting themselves in court to face cross-examination, to authenticate their opinions, that report, and I dare to add even the ECOWAS report of the same elections, tendered by second and third respondents, the petition numbers in the two petitions, are completely valueless and inadmissible for the purposes of authenticating the opinions expressed in them by the makers. See first on that the cases of Nyesom and Peter Said and Said Yasoso. It also makes no difference that the said reports have been put in the form of print. Books, it must be noted, cannot be cross-examined. On this, I find support in the celebrated case of Idudu and others versus Okumagba, where the Supreme Court, 1976, where the Supreme Court had this to say, and let me quote what the Supreme Court said. It said, as for the law involved in Idudu and Okumagba, we would like to point out that it is now well settled that there are 5 ways in which ownership of land may be proved. In our view, not only was the evidence of the witnesses, that is continuation, not only was the evidence of the witnesses called by the appellants rightly rejected by learned trial judge for good and sufficient reasons, we also think that he was right in not attaching any weight to the views expressed in the book cited in support of such traditional evidence. As Lionel Brett JSC, as event was rightly in our view once pointed out in a learned address given by him at the University of Lagos to the Nigerian Association of Law Teachers, smaller quote again, the courts are not to be hypnotized by the authority of print. The crucial fact is that books cannot be cross-examined, either as to the opinions expressed or as to the claims of the author to have special knowledge. If the author is living, there is no reason why he should not be tendered as an expert when this difficulty would vanish. More quotes, end quote of that side. Then the Supreme Court went on to say, moreover, none of the authors of these books in that Kumagba's case testified in support of the views stated therein, and no explanation was given for the omission. For all these reasons, we share the apprehensions of the learned trial judge about the value or weight of the traditional evidence as narrated by each of these authors, particularly as the authenticity and impartiality of the sources of their narratives cannot, for obvious reasons, be easily ascertained, end quote. I wanted to say that is the exact same situation we are confronted with here as regards both the European Observer Mission report and its brother ECOWAS Election Observer report. For purposes of proving the opinions expressed in them by their makers, neither of them is of any higher value than the mere sheets of paper on which it is recorded. And for those who, like the petitioners, are enamored by the now very familiar patronizing judgments passed on elections, regularly passed on elections, by European Election Observer Missions every 4 years. Even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020 presidential elections of the United States that saw him out of office was also a fraud, it may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read above, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough. It is for these few additions, but much more for the far more illuminating reasons advanced by my brother Haruna Samani JSC, his rulings and judgments, which reasons I concur with without reservation, that I also hold all three consolidated petitions not proved and thereby enter another dismissing all of them, and I affirm the declaration of second respondent Bola Ahmed Tinubu by second respondent as the person duly and properly returned winner of the 25th February 2023 presidential election of this country and duly elected president of the Federal Republic of Nigeria. I also abide by all other consequential orders, including that as a cause contained in the leading judgments.
I now invite my learned brother by my extreme left to present his own judgment.
Well, last but not the least, I've read before now a draft of the lead judgment just delivered by my learned brother Haruna Simon Samani, JCA, in the three consolidated petitions of CAPEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-2023. I'm in agreement with and I adopt all the reasons and conclusions stated therein, both in relation to the rulings on the objections and the merits of the three consolidated petitions. Although all the issues in petitions number CAPEPC 03 and 2023 and CAPEPC 05 2023 have been exhaustively resolved in the lead judgment, I deem it only pertinent to highlight a fundamental vice which has affected the two petitions, especially as it relates to the petitioner's essential contention or premise upon which they predicated those two petitions. In those two petitions, the petitioners have premised their ground that the presidential election conducted on the 25th of February 2023 is invalid by reason of corrupt practices and non-compliance on their contention that by the provisions of the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 2022, the first respondent, INEC, is mandatorily required to electronically transmit election results to the coalition system and to the INEC results viewing portal, the IREV. They contended that the first respondent had deliberately refused to comply with those mandatory provisions and had manipulated the results of the election through various corrupt practices which they allege in those two petitions. However, in both petitions numbers PEPC 03-2023 and PAPC 05-2023, exhibits X1 and X2, which were tendered respectively to show that the Labour Party, the second petitioner in petition number PEPC 03-2023, had before the elections approached the Federal High Court Abuja for the determination that, and I quote, by the provisions of the Electoral Act 2022, INEC, the first respondent, has no power to opt for manual method other than the electronic method provided for by the relevant provisions of the Electoral Act, unquote. And I quote again, an order of this honorable court directing / compelling the respondent to comply with the Electoral Act 2022 on the electronic transmission of results in the forthcoming general elections, unquote. In that judgment, the Federal High Court Abuja Division had dismissed the suit and held that, and I quote, there is nowhere in the above cited sections where the Commission or any of its agents is mandated to use an electronic means of collating or transferring of election results. If any, the Commission is only mandated to collate and transfer election results and number of accredited voters in a manner or way deemed by it. Additionally, this court's attention was referred to the judgment of this court in appeal number CA LAG CV 332-2023, APC versus Labour Party and 42 others, delivered on the 19th of June 2023, in which this court set aside the judgment of the Federal High Court, Lagos Division, in another suit number FHC LCS 370-2023, Labour Party and others versus INEC, filed by 8 Labour Party, the second petitioner in PEPC 03-2023, before the Lagos Division of the Federal High Court to obtain an order of mandamus compelling INEC to electronically transmit or transfer election results as provided in its regulations, after losing in the Abuja Division of the same court. In the judgment of this court of 19th of July 2023, in appeal number CA LAG CV 332-2023, this court particularly held at pages 23 to 24 thereof that, and I quote, it is difficult for suit number FHC LCS 370-2023, which gave rise to this appeal, to escape the label of abuse of court process. I said so because the objective of the suit is to compel the 43rd respondent to adopt a particular way of transmitting or transferring the results of the election in Lagos State. This objective is not in any way different from what the objective of the first respondent wanted to achieve in suit number FHC ABJ CS 1454-2022. Similar parties are the same in the two suits. The second to 42nd respondents are members of the first respondent, which litigated the suit number FHC ABJ CS 1454-2022. The second to 42nd respondent's interest is the same with that of the first respondent, so they are the first respondent's previous. Both suits are against the same defendant, that is the 43rd respondent hearing, and filed in the same court, albeit different divisions of the court. The decision of Emeka Nwite J of Abuja Division of the lower court, which dismissed the first respondent's suit, holding that on the interpretation of the provisions of section 60 subsection 5, 62 subsection 2 of the Electoral Act 2022, INEC, the 43rd respondent hearing, is at liberty to prescribe or choose the manner in which the election results shall be transmitted, finally settles the issue. I therefore find in suit numbers FHC LCS 370-2023, which is herein being appealed against all the trademarks of the cause of an abuse of judicial process, unquote. Exhibits X1 and X2, tendered in petitions number 03 and 05 respectively, as well as the decisions of this court in appeal number CA LAG CV 332-2023 Supra, are subsisting judgments of court which are not only binding on the parties, but which constitute issue estoppel to the petitioner's essential contention in the two petitions, that the first respondent is by Electoral Act 2022 and the INEC regulations mandatorily required to electronically transmit and collate results of the presidential election. The doctrine of issue estoppel is that once an issue has been finally decided by a competent court, the issue will not be allowed to be relitigated by the same or even different parties. See Cotton versus Oekami and another, APC versus PDP and others, Ezewani versus Onwodi, citations on the record. Indeed, in Ezewani versus Onwodi, the Supreme Court, Paoputa JSC, specifically held as follows. Strictly speaking, therefore, the concept and value of an estoppel is to bar a person from denying or asserting anything to the contrary of that which he has, in the contemplation of the law, been established as the truth, either by the acts of judicial or legislative officers or by his own deed or representation, express or implied, unquote. It is clearly evident that the decisions in Exhibits X1 and X2, tendered in the two petitions respectively, as well as the decisions of this court in appeal number CA LAG CV 332-2023, APC versus Labour Party, and 42 others, have dealt a death knell to the petitioners' contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines for conduct of elections 2022 mandatorily required to electronically transmit election results to the collation system and to INEC result viewing portal, which is the RF. Apart from this fundamental deficiency, which I have highlighted, the lead judgment just delivered had exhaustively considered all the other issues and rightly concluded, in my view, that the petitioners in petitions number PAPC 03-2023 and CAPEPC 05-2023 have failed to establish all the allegations contained in the two petitions. I adopt all those reasons and conclusions stated therein and also find the two petitions devoid of merit. Petition number 04, as regards that petition, the petitioner has, under the guise of challenging the qualification of the third respondent to contest the presidential election on the ground that he had violated the provisions of Section 142, subsection 1 of the Constitution of the Federal Republic of Nigeria 1999, basically challenged the validity of the nomination of the fourth respondent by the third respondent as his running mate in the 25th February 2023 presidential election. In concurring with the lead judgment just delivered, I also hold the considered view that the status of the nomination of the fourth respondent as the running mate of the third respondent and vice presidential candidate of the second respondent had been finally decided by the Supreme Court in appeal number SC-CV 501-2023, PDP and INEC, delivered on 26th of May 2023, now reported as PDP and INEC and three others, 2023 LPLR 60457 SC, the certified true copy of which was tendered as Exhibit X1. In the concurrent judgments of their lordships, Okoro, Augi, Ogunwumiju, Agim, justices of the Supreme Court, they have all determined as proper the nomination of the fourth respondent as vice presidential candidate of the second respondent. As for the petitioner's argument that the pronouncement of the Supreme Court in those concurring judgments is an obiter dictum, the clear statement of Ogunwumiju JSC has left no one in doubt that the Apex Court decided the merit of that case. My Lord Ogunwumiju JSC clearly stated at page 74, paragraph C of that judgment that it is apt in this type of political case of public interest to look into the merits of this case, unquote. It is settled law that once the issue relating to the status of a person or a thing is finally and substantively determined by a competent court, such a determination constitutes estoppel to any subsequent proceedings on the same issue. See APC, PDP, and others, Inakoju and others was the delicate citations on the record. Now, for all this, and all the detailed reasons succinctly stated in the lead judgment just delivered, I also hold that this petition is lacking in merit. Having also found that no merit exists in all the above three consolidated petitions, I join my learned brothers Amani JCA in dismissing all the three petitions and abiding by the consequential orders made in the lead judgment.
Well, with the judgment delivered by my learned brother Abba Mohammed, who have discharged our responsibility to the nation, we have concluded the hearing of this petition and we have concluded the delivery of the judgment. So we thank the Almighty God for bringing us this far. All these months, both counsel in all the petitions have labored, they have tried to represent their clients creditably. And we thank you for their assistance, because their assistance have helped us to reach our conclusions in this judgment. So as we leave today, we hope that very soon, both us and counsel will meet in our normal cases. Yes. These cases have tended to put a distance between us. But when we resume in our normal cases, we shall see and interact better. Thank you, and God bless us all.
Thank you very much, my lords. On behalf of the petitioners, with all sense of responsibility and urgency, there's a little request we want to make, given our severely limited time by the practice directions to exercise our constitutional right of appeal. We will request, because our time starts running today, if we can have the copies as we leave today, so that, because any day that we lose depletes our right. We know the day is far spent. It is our humble request, so that the registry, once we leave, will be able to collect from them. We are very grateful, my lords.
Well, I'm sure learned senior counsel is aware of the time now. It's 10 o'clock now. And, well, it's unfortunate. We understand your constraints, but you have to bear with us to tomorrow. Yes. Hopefully, you know, the judgments are a bit bulky. It's a consolidated judgment. We have to put
tomorrow we can have them from.
Yes, we have to put everything together, bind them, and give it to council.
We are very grateful.
Yes.
Tomorrow, my lords.
Wait. So we thank you for all the efforts you have put in. Thank you. Forget now.
My lord.
So, a day.
Yeah, sorry, my lord. I know the day is far spent. I thought my senior colleague will actually thank my lords for the industry put into this judgment. It is a well-considered judgment, and these judgments will no doubt change the face of our electoral jurisprudence. We have traveled this part of history this past few months, and today we have reached the end of it. We pray that that we all learn from it. We have all learned from each other during the course of our stay here. We salute you, my Lord, for the clear, detailed review of the pleadings, the issues, and the evidence in the petitions, especially on the issues surrounding technology. That was an area we thought we were going to have problems.
Please be brief.
But we thank you, my Lord, for this judgment, and we are very grateful. Yes. Thank you. God bless you, and God bless the Federal Republic of Nigeria.
Yes.
Well, my lords, mine is a short one. I thank your lordships. I think earlier on, my lord, there was supposed to be a misunderstanding. I apologize for that. It wasn't the intention at all. I appreciate your lordship's industry, and this work is not easy. I don't think I could have done any of the jobs your lordships did this evening. From 9:30 till now, I would have lost my voice. But I thank your lordships, and I pray that the bar and the bench continue to have a good relationship in all things. Thank you very much.
Sorry, my lord. Yes, I think.
My lord, I'm very sorry.
Well, we know. We thank you also.
Sorry, my lord.
Yes, we thank you for this.
No, my lord, I just have one or two things to say.
You are who? Who are you?
My lord, I'm counsel to the second and third respondents. Malik. Yes, my lord.
Oh, okay.
Okay, thank you, my lord. My lord, I'd just like to also register my appreciation for our appreciation. And I do this, my lord, with every sense of responsibility and on behalf of our leader, Chief Wole Olanipekun, Senior Advocate of Nigeria, who is unavoidably absent. My lord, I'd just like to say that I have listened to several judgments emanating from the world of the soul of this court. None of them ranked top as this one in terms of industry, scholarship, and all of the good things that we have seen evident and are on offer in this judgment, consolidated judgment delivered by the Lord. I think it is now time that my Lord take your deserved rest. We wish you good health, my Lord. God bless you all.
No, call the court, please.